Thank you for staying with us on Citizen Weekend. As promised, I'm now joined on set by Julie Wayua Matheka, who is a program manager, ICJ Kenya, and a former IPOA commissioner. He's also an advocate, and that is John Waiganjo. I will start, so we're looking at arrests and lessons that we can take away from the unfortunate death of Albert Ojwang in police custody. So I'll start with you, Julie. For what offences would you be summoned by police, maybe to record a statement vis-a-vis arrest?
Thank you very much, Olive, for the invitation to be part of this discussion. And I think before I start, I'd like to offer my condolences to the family of the late Albert Ojwang. And this is on not only my behalf, but also on behalf of the entire Kenya section of the International Commission of Jurists. We are deeply troubled by what has happened. And of course, we will be lending our legal expertise to see that justice is met in this issue. So in issues where, to just point to your question, in regards to summons vis-a-vis arrest, first of all, an officer can arrest a person because of a cognizable offense. If you shoot a person, if you are attempting a robbery, the person does not need a warrant. They can enforce the arrest immediately. So when you issued summons, ideally, it's for matters that, one, you need to offer a statement around as they're also doing their investigation. They are more or less misdemeanors, not necessarily felonies. But actually, police have the power to arrest a person for any offense that is cognizable, is before them, and they can actually see the offense taking place. So they don't necessarily have to get a warrant of arrest for every single matter. And that's important to note. The other thing is also the gravity and the seriousness of the offense. We see that for corruption offenses, more so, because of the technicality of it, sometimes warrants of arrest are issued because of also the documentation and the seizing of matters. But for some of them, you just issue a summon for someone to record a statement. So it's a varied response in terms of which matters per se can get a warrant versus which ones do not necessarily need a warrant. But we also see that more offenses actually can be enforced without a warrant of arrest.
Okay.
Yes.
So something like false publication, is that a cognizable offense or a non-cognizable offense?
It is a cognizable offense. You don't necessarily need a summon for that offense.
So all right. Okay. Julie, so let me ask you this, right? During the Gen Z protests,
yes,
the line between an arrest and an abduction was blurred.
Yes.
So according to the law, what should an arrest look like?
Okay. So I'll talk about an arrest in terms of what are your rights in terms of an arrested person. So former commissioner, sorry, we are so used to calling you commissioner. Former commissioner Waiganjo has actually stated that you need to be informed that you're being arrested. So we'll talk about Article 49 of the Constitution of Kenya that actually speaks to the question of the rights of an arrested person. A person needs to be informed that they are arrested. The police officer will tell you the reason for the arrest, the charge and the offense that you have committed in a language that you understand, and what they're going to do, which is effect the arrest. Following which they should tell you to remain silent. Therefore, whatever you say can and will be used against you. We also hear this a lot in the
movies.
Yeah, in the Miranda rights in the movies. But it's actually applicable, and it's actually there in Article 49, 1-2. So 1B, sorry. So you're supposed to be informed that you should remain silent, and anything you do say can and will be used against you as evidence. Thereafter, you're allowed to communicate with a family member, a lawyer, and a representative. And there comes in the question that you have asked in regards to what happened during the Gen Z protests. A lot of persons were being held incommunicado, which is actually illegal, because you should be able to communicate to a legal representative and inform them that this is the charge with which you're being arrested on, this is where I'm being held, bringing me to Article 49D, which states to the fact that you should be held in a gazetted facility, which is known as a detention facility. Therefore, we should know you're in police station 1 or 2. If you're in Central, we should know you're in Central. You should be validly be booked in within the occurrence book, and then we should be able to trace what was the occurrence. You were arrested at what time, with which officers, which condition were you in when you were arrested? Because that is also a very important issue that has actually played out in this matter.
Yes.
What condition were you in? Did you ask for medical support? Did you ask for legal support? Was that denied? And what are the reasons for the denial? Another thing that is important and has actually been drawn out in another case, which is in appeal right now, it's a Naftali Chege case, which actually had similar circumstances whereby a person died while it's in custody. The judge in the High Court matter, in the High Court, actually went to spell out that there are certain things that exist in the National Police Service standing orders that are not being followed through, which is documenting of the medical status of the person who's being brought in, the cell in which they're being booked, and installation of surveillance cameras in those cells. We saw that in this particular instance, there were surveillance cameras, but they were not active. They're supposed to be active because we need to have complete transparency and accountability around the person who's being arrested. Remember, you're not an accused person in this particular juncture. You're an arrested person.
Oh, you're an arrested
You're just an arrested person. You're a suspect. You're in police custody. So once you have been detained, you are supposed to be separated from persons who are already serving a sentence. You should not be detained with persons who are serving a sentence because you're innocent until proven guilty. So you should be separately held. Another thing is, for most offenses, you should be released on bail and bond. And as has been rightly stated, unless there is a serious reason as to why you can be denied bail and bond, most offenses you should be released on bail and bond, if not all. Most offenses, if not all. The reasons as to why you'd be detained, for example, is for your own safety. It happens in certain instances whereby a person is detained in police cells for their own safety, for the safety of the community. Because of the gravity of the offense, because of the likelihood of committing another offense, similar to that offense that you have committed. Another issue could be, of course, the fact that you're a flight risk. Some people, if given bail on bond, will escape. So there are certain circumstances, but the non-derogable circumstances are every person, whilst in police custody, is to be treated humanely, with freedom from torture, cruel, and inhumane treatment. You should not be tortured. Article 49 clearly states that you should not be coerced to give a confession. Inducement to give a confession, which is that your charges will be dropped if you agree to the fact that you did this offense, which could be more or less looked at as you're bargaining with the officers. That's inducement. But also coercion in the sense of torture being meted out on you to make a confession. That should not even be admissible. So you find that persons who are arrested need to know these rights, which are clearly spelled out in Article 49, because it will protect them. When you're in police custody, ensure that these rights are upheld. Do not give a confession without the representative of a valid advocate or someone who can plead your case. And also at the same time, Article 49 speaks in two ways. It's both procedural but also substantive, in the sense that it gives a duty to police officers to ensure that the arrest is carried out in a proper fashion. And if it is not done in a proper fashion, will actually lead to an illegal arrest. And as such, evidence in court being brought that the entire process of arresting this person was illegal. So that is actually an important consideration, particularly in the instances that we have seen play out in the last 1 week.
All right. And Julie Matheka, who is a program manager at ICJ Kenya, thank you for helping us better understand these issues that have come up.